Assalamualaikum warahmatullahi wabarakatuh. My name is Roandriyo Firdausi. My student ID number is E1A025116 from class B. And right now I'm studying law at Universitas Jenderal Sudirman. And I'm taking the English for Law course under the instruction of Mr. Mustafa Tabibkayadi, S.Pd. M.Ed., and Miss Nissa Roiyasa, S.Pd. M.Ed.TESOL. Today, I will present my analysis of the trademark dispute case between BMW Group Indonesia and PT BYD Motors, PT BYD Motors Indonesia, concerning the use of the M6 trademarks. The background of this case started when BMW Group Indonesia filed a lawsuit against PT BYD Motor Indonesia at the Commercial Court of Central Jakarta District Court on February 26, 2025, with case numbers 19/PTD.SAS strip HKI Merck 2025 PN Jakarta .pst. What becomes the background of the case is BMW objection to BYD use of the M6 name for the electric MPV vehicle launch in Indonesia in 2025. BMW claims that M6 is an iconic trademark that has been associated with the luxury sport vehicle line from the 6 series under the BMW M sub-brand. According to the Director General of Intellectual Property (DGKI) database, BMW AG officially registered the M6 trademark on August 20, 2015 with application number D0021 D002015 35540 with protection expiring on August 20, 2025. The main issue is whether BYD use of the M6 trademark constitutes trademark infringement under Indonesian law, specifically whether it violates BMW's exclusive rights as registered owner of the M6 trademark in Indonesia, and whether this usage may cause public confusion regarding the origin and quality of the vehicles. Another critical legal issue is the conflict between the first to file principle in the protection of well-known marks. While BYD has used the name BYD M6 globally since 2009, and BMW registered the M6 trademarks first in Indonesia, creating a complex legal situation. Uh, this case primarily uh, governed by several key legal provisions. According to Article 1, Paragraph 5 and Article 3 of Law Number 20 of 2016 concerning the trademarks and geographical indication or trademark law, Indonesia adopt the first to file principle, which grant trademark rights to the party who first registered the mark of the mark with the Directorate General of Intellectual Property of DGKI, based on the statutory framework of the trademark law, particularly Article 21, Paragraph 1, letter B. A trademark application may be rejected if it has similarities with a well-known marks, whether for similar of or non-similar goods or services. The applicable legal norm in this case is that the determination of well-known mark status status is based on several factors, including the level of public recognition, widespread use, global promotion, and registration in various countries. Under the provisions of the trademark, allow the trademark's owner has exclusive rights to use, license, or prohibited to use the trademark by other parties, providing legal certainty in the business world. On July 2, 2025, the Commercial Court of Central Jakarta District Court issued its decision rejecting BMW lawsuit. Uh, Based on court reason, the court made a well-reasoned decision because it found that BMW lawsuit was premature. Why? The court reasoning was strong in establishing that BYD 6 trademark was still the substantive examination stage at DGKI under application number DID 2025 122106 at the time the lawsuit was filed. The court correctly applied the law when they determined that BMW should have first filed an objection to the BYD M6 trademark registration with DGKI and await the final decision on the trademark application before bringing the case to court. So, based on that, the ruling is consistent with established legal principle regarding the power legal procedure. The court properly recognized that the M6 and BYD M6 are two different legal objects, and importantly, there was no evidence that BYD Company Limited has actually produced or circulated product with the M6 mark alone in Indonesia. The judge correctly applied the law by referring Supreme Court decision number 591.K/PDT.SUS HKI/2015 and Supreme Court decision number 200K/PDT/1988, which established that premature lawsuit should not be accepted to avoid conflicting decisions that could create legal confusion. So, however, the court decision is questionable due to its purely procedural focus. The judgment appears to be flawed because it did not address the substantive merits of BMW's trademark infringement claim or examine whether public confusion might occur. The court failed to properly address the broader implication of the first to file principle versus well-known trademark protection. Additionally, the ruling did not consider BMW's legitimate concern about brand dilution and the potential weakening of the M6 brand's premium status through association with a lower cost vehicle segment. I partially agree with the outcome of the court decision from the procedural standpoint, as BMW should have followed proper legal channels by first filing an objection with the GKI. However, for me, its lack of substantive analysis regarding the potential of for consumer confusion and trademark dilution. In my opinion, while the decision was procedurally procedurally correct, it leaves unresolved the fundamental question whether the BYD use of M6 might infringe upon BMW's trademark rights and cause market confusion. The authorities failed to properly address the tension between Indonesia's first to file system and the protection afforded to international well-known marks. This decision sets an important precedent for trademark dispute in Indonesia, particularly the automotive sector. It emphasized the critical importance of following proper administrative procedure before seeking judicial remedy. For international brands operating in Indonesia, this case highlights the necessity of promptly registering trademark in Indonesia, as global use of or international recognition alone may not provide adequate protection under Indonesian first-to-file system. From an ethical perspective, the case raised questions about corporate responsibility and good faith in trademark registration. Companies should exercise due diligence to avoid adopting marks that might conflict with existing rights, even if technically available for registration. Socially, this case demonstrates that the Indonesian legal system seeks to balance the interests of establishing global brands with the principle of fair competition and proper legal procedure. It also shows that procedural justice is as important as substantive justice in maintaining the integrity of the trademark system. In conclusion, the BMW's versus BYD's trademark dispute illustrates the complexities of trademarks law in Indonesia, particularly the intersection of the first to file principle, well-known trademark protection, and procedural requirement. While the commercial court decides was procedurally sound in rejecting BMW premature lawsuit, it left significant substantive issues resolved, and the case emphasized that business operating in Indonesia must be proactive and register their trademarks and following proper administrative procedure when dispute arise. So that's uh, the case that I want to show you. Thank you for listening me, and wassalamualaikum warahmatullahi wabarakatuh.